Hello friends, in the series on the income tax cases, today we will discuss once again a very important case on section 148. The crux of the case is that whether before issue of notice under section 148, it is obligatory for the assessing officer to apply his independent mind or to do the inquiry regarding the information which the assessing officer has and the alleged income escaping assessment which the assessing officer is alleging. The moot question before the court in this writ petition was that if the assessing officer issues the notice to the assessee without making independent inquiry, in that case whether the notice issued under section 148 will be as per the jurisdiction of section 147 or not. This issue has been very well taken up by the Honorable Bombay High Court in the case of B.U. Bhandari Auto Lines Private Limited versus Assistant Commissioner of Income Tax and others, and this case is reported in 456 ITR at page number 56. The date of the judgment is 10th February 2023. The facts of the present case are like this. In the present case, the assessment year is 16-17. A notice under section 148 was issued to the assessee, and when the reasons were supplied to the assessee, in that reasons it was mentioned that some information has been received from the Deputy Director Investigation, and in that reasons it was mentioned that there was a search in case of M and others wherein some demonetized currency was seized. In that search, which was done in the premises of M named R as key accomplice and mentioned that he was connected with a shell entity MT. On the basis of this information, the assessing officer, after examining the VAT returns of the assessee and examining that the assessee has made sales to the company MT, alleged that these sales are bogus and the income has escaped assessment. These were the reasons which were given to the assessee. The assessee filed the objections against these reasons, which were as usual rejected by the learned assessing officer. So the assessee filed the writ petition before the court. When the court heard the matter, the court said that in the present case or in the matter of reopening under section 148, the reopening should be tested on the basis of the reasons recorded, which could neither be improved upon or substituted by an affidavit. The court said that in the present reasons which have been supplied to the assessee, it was not alleged that entity MT, with whom the assessee has the transaction, was being run by R for purportedly providing accommodation entries. The court said that it was not mentioned in reasons that on what basis AO has concluded that MT is a shell entity. The court said that in the present case, there was no reasons to show that the transactions were non-genuine. The court said that in the present case, the learned assessing officer has grossly failed to make any independent inquiry, and from the facts of the case, it appears that the learned assessing officer has not applied his mind in recording the reasons and establishing that there is a live link between the information in hand and the income escaping assessment. The court said that and relied on the Supreme Court judgment in the case of ITO versus Lakhmani Mehwal Das 1976, which is reported in 103 ITR at page number 437, and the court also referred the judgment of First Source Solutions Limited versus Assistant Commissioner of Income Tax, which is reported in 438 ITR at page number 139. So the court quashed the notice under section 148 on the basis that the information on the basis of which the assessing officer has issued the notice under section 148 was not tested by the assessing officer by independent inquiry, and it was a clear-cut case of borrowed satisfaction, and which is not the mandate of section 147. From the complete case, it appears and it comes to apparent that if we analyze the history of section 148, then there was section 34 of 1922 Act, in which there was words definite information on the basis of which the assessing officer can issue the notice under section 148. After that, the definite information was replaced by reasons to believe, and now this reasons to believe has been replaced by information to suggest. But if we analyze the jurisprudence on section 148 notices, then it is very clear that whatever the information the assessing officer have, it is the bounden duty of the assessing officer to establish a live link between the information and the income escaping assessment. On the bald allegation and just copy pasting the information received from the investigation wing, the assessing officer do not have the jurisdiction to issue the notice under section 148. At the end of this video, once again I am repeating the name of the case. The name of the case is B.U. Bhandari, Auto Lines Private Limited versus Assistant Commissioner of Income Tax and others. And this case is reported in 456 ITR at page number 56. And the matter has been decided by Honorable Bombay High Court on 10th February 2023 and which has been recently confirmed by Honorable Supreme Court. Thank you, friends.